Welcome to another episode of the IMG Roadmap podcast. And this one is specifically for my non-US IMGs. So those of us who have a visa or will be applying for a visa to go to residency or fellowship, or for some of us who have recently gone through that process and are seeking J-1 waivers, H-1B transitions, this episode is exactly what you need. Now, with all the policy changes happening lately, I've been receiving tons and tons of questions on Dr. Loom. What does this mean for us? How is this different from when you went through this process? And yada, yada, yada. We all know that I don't have any legal background, so I brought in an expert because if we can hear from the people that actually understand the law and work with physicians like ourselves, then maybe we could be more informed as to what steps we need to take in preparing towards that residency position, that fellowship position, or that first attending gig. So I invited Esquire of Honor, Kaushik Ranchod. He's the founder, attorney, and CEO at the Ranchod Law Group in California. And he's coming in today, and I'll just give him the stage because he has a lot to share with us. So stay tuned, grab a pen, a piece of paper, and take some notes, and we'll have all resources tagged below in the show notes. Mr. Ranchod, welcome to the podcast. Can you share with us a little bit about you, where you practice, what you do, and what you're so passionate about?
Sure. Hi, Dr. Lemon, and everyone who's listening. It's great to be here. I'm so excited. I love talking about immigration and physician issues, which we do a lot of at our firm and J-1 waivers. I've been practicing for 25 years, and this is an area that we're very passionate about because we really believe that if we are able to make an impact to a physician, you're making an impact to so many patients and it has a ripple effect. I was just reading a statistic that 1 out of every 4 physicians in the US is foreign medical graduate. We're relying on FMGs in this current healthcare shortage that we have. So this is not just something that is just about immigration. It's about the how is our nation going to be impacted as a whole. So that's why I'm so passionate about this because it goes much more beyond immigration and it goes beyond making an impact and a little bit personal about myself. I have a son and I have a 2-year-old rescue dog.
Awesome. What breed is your dog?
He is half Shih Tzu and half Terrier. That's what we're guessing. Yeah, that's because we don't know because he's a rescue. And
Uh,
he's a small dog, like about this big, but we've had him for 2 years. It's brought a lot of joy to our house.
oh, that's awesome. We love it. So let's just get right into it because I'm sure the people have questions and they want to know. Can you give us an overview of the current changes within the H-1B system in the United States today? We're recording this June 2026. What do we know now?
Okay. So in terms of H-1B, many of you have already heard about the H-1B proclamation of the $100,000 fee that was put out in late September 2025. So that's been the big change. Now, it's really important to separate fact from fiction. So some of the things that are true and not true. So it does apply to individuals who are outside of the United States, but if you're like here on, for instance, a student visa, you can change to an H-1B without having that fee. So it doesn't apply to you if you're changing status within the United States, but it does apply to you if you're outside of the United States. That's called consular processing, where you're applying at the embassy. That's where it applies. And right now, this litigation has been the ping pong battle. So the district court had ruled that this is not lawful. And then the Trump administration appealed it, and now it's at the appeals court, and we're waiting to hear a decision right now on whether or not they're going to uphold the law or not. Because essentially, the government is legislating by creating this $100,000 bill, and it's ridiculously high, and it seems like common sense, but we have to wait for the appeal court to make their decision.
And so for physicians that are starting out, they're outside the United States where these rules apply. Have there been any bills lately that have come up that could potentially overturn this? And do you know of any progress with any of those?
I know the AMA is lobbying with many other physician organizations. There is a caveat within the $100,000 if it's within the national interest to get this to be within the national interest, which it clearly is because many physicians are working in underserved areas and there's a shortage of physicians. So there is lobbying going on for that, and it's been very assertive lobbying, but there's nothing that's passed yet. But if you look at the pathway of the physicians coming into the US, usually they come in on a J-1 to do residency and then switch to H-1B. And then, so there isn't that consular processing component in that. There are physicians who come in to do residency in H-1B as well, but that's less common. But the problem is do you have to, let's say you're applying for a Conrad 30 waiver where you're working in an underserved area for 3 years and your residency ends and your status may expire by July 30th. And then if you have to go home, that's where that becomes a real issue because then you're stuck with that $100,000. We are just waiting to see what the appellate court says on this ruling.
Okay, so there's still a lot of unknowns regarding whether I've been following with the news and I saw that the AMA did indeed, they're lobbying alongside with the American Academy of Family Physicians, which is an organization that I'm a part of, as well, are supporting the AMA in that. So it sounds like there's more to come on that part of things. And then for the physicians that are in the US, maybe on a B1, B2, completing some kind of visiting rotation or visiting elective, because there's some students that I know that come in from Caribbean medical schools or they come into the US from other methods and then they're doing some kind of clinical work, not clinical work necessarily, but clinical learning experiences. So rotation, some kind of research work, and they may be on a B1 or B2 visa or something like that. If that person was transitioning over to residency, and aspiring towards an H-1B, is that something that is available to them as well?
So they were able to get a change to a J-1 and do the residency as a J-1, and then you typically would go from J-1 to H-1B through the Conrad 30 program or the HHS program or VA program, like interested government agency program. So that could be the immigration pathway.
Okay. Can we talk a little bit about the Conrad 30 program? And I think there's been so much focus on the H-1B side of things, but does that affect the Conrad 30 program?
No, it doesn't affect it at all. You can still change from a J-1 to an H-1B within the United States. So it's business as usual in terms of if you're in the United States, it's when you leave the United States. So that's why it's also advisable and be very careful leaving the United States to because one, if you're applying and you have your H-1B pending, that could be a situation where your application is abandoned or you might subject yourself to consular processing.
Ah, so it almost sounds to me like if I was starting residency now, my best bet is to lean in toward the J-1 visa side of things as opposed to trying to start residency on an H-1B with the uncertainty around it. Because $100,000 for a residency program to pay is a lot of money. And to expect that of a residency or a fellowship program is, I think, unrealistic.
Yeah, it's very unrealistic for for hospitals or underserved areas to be able to pay $100,000 fee. That's why it's in effect just a way to keep people outside the US. And I think the J-1 would be better in residency than the H-1B because there is so much uncertainty with it. And the J-1 can lead to an H-1B or a green card if you get the waiver, depending upon those options. And there's another option that we haven't talked about applying for a hardship waiver, where if you're married to a U.S. citizen or you have a lawful permanent resident spouse or you have a U.S. citizen child or lawful permanent resident child, you could also file for a hardship waiver as well. If you're doing residency, that takes about a year and a half to 2 years right now. So you want to plan ahead for that. That would be another pathway too.
Yeah. And so speaking about J-1s, I would like us to talk a little bit about the J-1 program for the person who's listening and has no idea what we're like referring to. Because I think when I started this process, I did not really know what was happening. I was just learning as I went along. Can you give us an overview of what the J-1 program really is and how it works for physicians specifically?
Sure. Yes. And I think you all get thrown into the system and there's all these requirements you didn't even know you signed up for, like having to go back for 2 years. And thanks for sharing that so I can dial it back a bit. So with the J-1, it's an exchange visitor program. So the whole concept behind it is you're supposed to take your skills back to your home country. So that's why there's that 2 year home country requirement because you're supposed to come here and then you learn whatever your residence you did in residency and then take that back. So that's why you need to have a waiver because if you're the government's saying, okay, you made this an agreement that you were going to go back for 2 years, but now if you want to change your mind, you need to work in an underserved area for 3 years, or you need to exceptional hardship to a U.S. citizen, a variety of these different J-1 waivers in order to be able to stay in the U.S. So many physicians come to the US to do the residency in the J-1 program. And so that's how that whole J-1 system begins to start, and you get subjected to the 2 year home residency.
Awesome. And so when I think of the J-1 program, obviously it's what I chose and it granted me was an annual sort of renewal process each year. I was given like 12 months on a DS 2019 and then it would renew each year for the entirety of my training. But when I had to, towards the end of it or somewhere midway, I had to apply for a waiver. And so can you share with us what the options are for waiver applications? I did the Conrad 30 as far as I can remember, but I heard you say earlier there are several options for waivers outside of the Conrad 30. Can you share a little bit about that?
Yeah, sure. You bring up an important point. I just want to bring up some new legislation that's passed or new rules that have passed. So, Boo, you mentioned how you would renew your DS 2019, and if you're on a J-1, you'd have a duration of stay. You would notice that, like on your I-94 or on your DS 2019. That has recently been changed to where now you have to get an I-94 every year. And so that's going to require physicians to be much more vigilant in the future to keep track of applying for this ahead of time. Hopefully that's going to get overturned because it just doesn't make sense. You're going to be
No.
staying here and having to continue to renew and having to apply every time for new I-94 is going to be a headache for everybody. So wanted you to just give you that latest update that just came down the pipeline like about a week or two ago. But yeah,
Yeah, it's
and it
scary because I remember just the process of thinking about my DS 2019 or whatever. And I would, the few times I left the United States to go outside of the United States for even medical mission trips that I took to Haiti, for example, I had to go to the American Embassy in Haiti to get a new stamp such that I could go back again the following year. Otherwise, my current stamp would have expired during that duration. And so now it sounds like, and that was a very difficult process because then you get it when you come back in. I believe you get an I-94 when you come back in. But that was something where I could have been stuck in Haiti for all I knew. But it sounds like now you have to get an I-94 renewal regardless.
yeah, so you're gonna and you have to keep track of that time. So make sure that you renew well in time to get your new I-94.
Yeah,
And now there's unlawful presence that comes along with that. If you overstay your I-94, where if you're on duration of stay, there's no unlawful presence that would be accrued. So last time the Trump administration tried to do this, it was overturned. We're hoping that's going to happen again. But right now, that's what the law of the land is right now.
interesting. Yeah. So,
But
yes, go ahead.
I was going to get back to your original question. I wanted to make sure that everyone was updated on that latest update. But yeah, there's a variety of J1 waivers. So there's the most common one that you may be aware of are the Conrad 30, where you work in an underserved area for 3 years. You're not allowed to apply for a green card during that time. You don't get the J1 waiver until you fulfill the 3 years, and you do that in H-1B status. There's also the HHS waiver, similar to the Conrad 30, and that's if the facility that you're working at has a very high health professional shortage area score. Then you could also work in those locations as well. Not as a specialist, though, that's intended for primary care. And then there's the VA waiver where you can work at a VA hospital as well. And then there's the exceptional hardship waiver, which I mentioned earlier, which we also handle many of those where if you are married to a U.S. citizen or lawful permanent resident or have a U.S. citizen or lawful permanent resident child and you show exceptional hardship to them, then you would be able to stay. And the way that you do that is, for instance, by demonstrating if their mental health hardship to your spouse or do they have health issues, career hardship, are they going to be able, if are they physicians too? We've done cases like physicians from Canada. If they had to go to Canada, the whole licensing process and being able to practice there would take time before they would establish their career there. So their career, there'd be career and financial hardship or certain country conditions of the country. So those all would be types of hardships. There's another type of waiver called a no objection statement waiver that I want to make sure that you all are aware of as physicians that you're not eligible for that. That's specifically not allowed for physicians in the regulations.
Wow,
So
why is that?
I guess the concept is that your country is saying that you don't object to you going back. That's what the no objection statement waiver is. And since this is specifically carved out for physicians, I think just how immigration policy developed over the years when these waivers were allowed and the J-1 program allowed, that was one thing that wasn't allowed in the rulemaking process.
Wow, wow. Okay, lots of information there. Now, in your practice, what would you say is the proportion of physicians who seek out H-1Bs versus J-1s versus other statuses for training and residency? And what are you seeing currently?
We currently work with physicians who are in J1s. We come in after the residency stage. So H1Bs and J1 residents are already working with the residency program. So we're not really working with H1Bs in who go into residency. That usually that residency program handles that. So we're usually working with the J1s who need to get rid of their 2-year home residency requirement and do the waivers for them.
Okay. So, as far as looking at those who are graduating now on a J-1, let's talk about those people. So I have a few people that I've mentored into residency and now they're done with or about to be done with residency and they're seeking their transition into the H-1B world. Most recently, somebody I can think of right off my head had a really long delay in getting her approval for the switch from the J-1 to the H-1B. And she's from one of the countries where there's a temporary suspension for immigrant visas in general. So we were wondering if this was going to transfer over to her presence in the United States. But thankfully, she did get her waiver approved just last week or 2 weeks ago. But I guess speaking to those people who are on J-1s right now who would want to go into an H-1B status, what can they do to prepare? Because there's so much uncertainty and so much fear and doubt as to if they'll have the opportunity to be able to do that in a year, right now, in 2 years. So, what is the best course of action for that person?
To start early in the process. You want to start, if you're going to do the Conrad 30 program, start looking for an employer early in the summer before your last year. If you're going to do the hardship waiver, start 2 years ahead of time. That's the best way because it comes down to timing. And another update, the courts pushed back on Trump's rule with the 39 country pause where there was 39 countries that were not allowed to move forward. So the court found that was unlawful. And so now if you're one of those 39 countries, your applications can move forward. That's within the United States. That's different than the 75 country pause outside the United States for immigrant visas. But immigrant visas only applies to green cards. It doesn't apply to what's called a non-immigrant visa, which would be like the H-1B visa or J-1.
That's a very good distinction because I think that there was some confusion, even on my part,
Mm.
as to whether the pauses were going to affect people, individuals from those countries that are physically present in the US, even though they're seeking, like you mentioned, a non-immigrant status. So
Yeah,
let's
and
just
even
speak for a
this,
moment. Yes, separate those two for us for a moment, the non-immigrant status versus the immigrant status.
yeah, so non-immigrant means that you're not intending to immigrate, basically. It's a temporary visa. Immigrant means green card base. It's like you're applying for a green card. But it's a green card outside the United States. So that's why it's called an immigrant visa. You're intending to immigrate. We're non-immigrant. would be H-1B, which is a dual intent visa. So that means you can have the intent to stay in the United States, where J-1 is a non-immigrant, like where you're supposed to come to the United States and then go back. Same with the F-1 visa. And those all look to your immigrant intent as well.
Mm.
Which brings up another issue. There, on May 21st, the administration put forth the memo for green cards, where they're saying if you came in on a non-immigrant visa, like a visitor visa, we're we would prefer if you apply at the U.S. Embassy rather than in the United States. And we're waiting to see how this all plays out. I just had an interview where the officer said they're waiting for more instructions from headquarters. So we're still moving forward filing green cards, but now it looks like there's going to be more hurdles to jump through. You have to show positive equities. It's not like you meet the requirements for a green card and you're just going to get it. This is primarily applies to family and employment, but for marriage and family, it seems like it's going to be harder on that end than on the employment end. But every case is going to be different depending upon
Different.
like how you immigrated to the US.
Okay. Wow. So it's just not about completing your medical underserved requirement anymore and putting in your green card application. They'll be looking at all the details of your case, how you first moved to the US and how that impacts your we're talking about H-1B to the green card process now.
Yeah, let's look at the hypothetical. You came here on a J-1 and then you did your H-1B in a Conrad 30 program, and then after the 3 years you get married. So now they said they're going to analyze your immigration history. So you came in on the J-1, that's a non-immigrant visa, and then you stayed. So that's a middle of the road and how they're going to evaluate that. But then you switch to H-1B, so that's more favorable. And then you're also doing something in the national interest, working in an underserved area. That's another positive equity that could be argued in that situation. So in that situation, that's going to be a bit of a stronger case than someone who came in on a visitor visa and then overstayed and then applied for a marriage-based green card. That they've said they're going to look at negatively, and you really have to show a lot more positive equities to overcome that.
Yeah. How about the folks who have an employment authorization card and maybe they have that on the basis of either being like a refugee, an asylee, or some other status, DACA or something along those lines? How does this affect them and what does this mean for them? Are they just gonna coast on an EAD throughout the rest of their lives, or do they have options here? And I know this is very broad and it's case by,
Mhm.
but any comments on the EAD folks?
That really depends on what pathway they choose and how they entered the United States. So what we always look to is like, how did you enter? Did you enter lawfully? Because that's really important for immigration purposes. Did you enter with the visa or were you admitted in? Did you get an I-94 card? Because if you didn't, then you're going to need a waiver to overcome the unlawful entry in many situations. But let's assume you entered lawfully and then you were on EAD because you are on DACA or something of that nature. So one thing that, and then you get married to a U.S. citizen, they're going to look at how long have you been in the United States. So that will be a positive thing for you versus if you're just here for a shorter amount of time. They are, just in my experience, if you are on asylum, they really are scrutinizing people who entered on asylum status. So for
Mm,
instance, we had someone contact us who was a citizen, came in as through the asylum program, filed for their parents a green card. Then they denied the parents' case because they said that the parents were alien smuggled the person who's now a citizen because, like, when he was 15 or something, they helped drive him to the airport or something of that nature. So,
wow.
yeah, so they're going back looking at that level of detail, especially with asylum cases.
Wow. Wow. I have never heard of that before because I've actually recently filed for my mother to become a permanent resident. But yeah, I did not come in as an asylee, but that's very interesting. That is the way that it is now. Wow. That's interesting.
Yeah, and I noticed that level of scrutiny primarily for asylum people who came in on asylum status. But they will also, if you're applying for citizenship as well, go in and look at like how did you originally come in? Was it all lawful? Did you
Yeah,
misrepresent anything? Did you say you're married when you weren't married?
yeah. So it's important that people keep clean records for the for those listening, and then also remember everything that you have previously submitted. So don't get confused about your past.
Exactly, exactly.
Yeah, yeah. So I also noticed that on the internet, you authored an immigration law handbook called Foreign Medical Graduate Hiring Made Easy. And I'm curious, what do you tell the employers and the people that are seeking to hire us to make them continue to hire us? How does this work for the employer? I want to get into the mind of the person hiring a foreign medical grad. What are they looking for usually?
Really, it comes down to the fact that there's a need for physicians and they can't find a US physician. So they're looking at other resources and someone who and foreign physicians are of course very hardworking and are able to do the job. And then there's also the bona fide need that's there that they can't find anyone else who wants to work in an underserved area where they're located at. So it's a combination of all those factors.
Yeah,
And that need hasn't changed. And statistically, that's only going to get worse with baby boomers and everything else. There's already a healthcare shortage, and this healthcare shortage is only going to get more bigger and bigger. So I know when I go to the doctor, when I want to see a specialist, I'm waiting for 3 months. I don't know how much longer it's going to be. Like with these immigration policies that are there, that is going to cause us to not be able to have doctor appointments and maybe not have a psychiatric office in our hometown because there's not enough physicians. So this isn't just
yeah.
talking about it affects us as a country as a whole, it's not just a microscopic one group of people that it's targeting.
I agree. It has a domino effect when
Hmm.
you restrict hiring for foreign medical physicians. You are not helping the shortage problem in the short term or the long term. Because historically, obviously, us, have gone into these underserved areas with a lot more joy and a lot more willingness to work there for multiple reasons, but the attraction for a lot of American graduates is low to go work in areas that are considered health professional shortage areas because it's hard. It's a harder job, a lot more
Yeah,
responsibility,
yeah.
a lot more burden, and it's best when you have support in a bigger city, but not everyone can practice in a big city, and not everyone should practice in a big city. So it definitely has a ripple effect, starting with affecting people who have limited access to care. And then it's always going to trickle even in the urban areas over time. I agree.
Yeah, and I think if we look at also some of the reasons that US born physicians may not practice in rural areas, they come out with, and I'm not sure if this is true for medical graduates, but I know US physicians come out with really high student loans. So
Yes.
sometimes they have to stay in a metro area because they have hundreds of thousands of dollars of student loans that they have to pay off. And so they're just not able to go into an underserved area, which, and so the fact that many physicians are willing to go in an underserved area who are foreign medical graduates is really keeping us afloat as a nation and serving the medical needs of a certain population that wouldn't otherwise get medical care.
Yeah. Wow. So another point that I wanted to chat about today was in researching about you, I saw that you lectured on alternatives to the H-1B visa. And I was curious about that because in looking you up and reading about your work, I learned that you've done this work for lecturing on I-9 verifications, E-Verify, Social Security, mismatch letters, and so on. But when I saw the alternatives to the H-1B visa, I thought, what would that possibly be?
So there are alternatives such as the O1 visa that are really good option for physicians, but it depends. That's more geared towards specialists because you have to show you have extraordinary ability, you've won major awards, or you have citations, publications, or it's looking and going directly to the green card option is what you're doing in the national interest, a national interest waiver, or having your employer directly sponsor you for the perm labor certification process, where they're showing there's no other qualified U.S. workers who are able to fulfill that job. Or
Mm.
you can continue your Conrad 30 program and do a national interest waiver for a total of 5 years in that underserved area. So those are some options that could be
All right.
available.
Yeah. And how about for the physicians that graduated from US medical schools? Do they face the same maybe conditions or do they have the same pain points or as far as when it comes to if you graduate from a medical school here, you were on an F1 status and then now you have to go into residency. Do they do OPT for residency or do they typically are able to switch over to J-1 or H-1B as well? And is this H-1B issue going to affect them too?
So we normally work with the residents who are already in J1 status, like, and doing their residency in the J1 program. So we're one step removed from that process, and I don't
Mm,
get to see that whole life cycle of where they're starting off from the medical residency program. But you could theoretically go from F1 to H1B from the university to a residency program if the residency program allows it.
yeah. And where do you see doctors out of? So I know you're currently in California right now, but if someone's listening and they're like, oh, I want to learn more about Mr. Kaushik, Ranchod's practice and get in contact with them. And I say that because I see that you also have served as a director of the South Asian Bar Association in Northern California. And I have a lot of my audience that are of South Asian origin, different countries throughout that area that either have coached or work with or listen to this podcast as well. So if someone wanted to reach out to you, do you have to only practice in the state of California or can you work with people in states that are outside or non outside of California or people that are outside of California?
Yeah, so immigration is federal law, so we represent clients throughout the 50 states. It's not like family law, or there are practices where you only can practice in that state. So we're allowed to represent clients throughout the US. So you could be in New York, even though we're in California, and we could still represent you.
Okay. And do you represent more of the hospital side of things or the hospital and their employee?
We tend to represent smaller employers and the employees. So
Okay.
mostly employees and smaller employers.
And small employers, would that be private practices, like
Yeah,
physician-owned,
private
multi-practices?
practices.
Okay.
Yeah.
Okay, that's good to know. So if I ever wanted to open a practice and decide to hire other foreign grads to work alongside of me, then you would be the guy I'll be reaching out to. Is that right?
Yeah, exactly.
Okay, awesome. That's good to know. So as we round up on our interview here, what are some take-home points for what you think would be the vision of this person, this ideal person that is a physician J-1, currently in the United States? Let's talk to two of them. First, the first person is currently in the United States. They're in residency and they're freaking out, just absolutely freaking out about what the future holds, not sure if they're going to ever get to an H-1B, if they're ever going to get to a green card. They obviously want to do a waiver, do not currently desire to do a 2-year return program to the home country. What do you think is the future for this person, given everything we know now?
The future for that person really has not changed. There's a lot of noise and rhetoric,
Hmm.
and it's just stay calm, stay focused, and plan. So we can't control that Trump's creating a $100,000 H-1B bill, but the reality is it doesn't apply to you unless you leave the US. So start early and plan looking for employers early if you want to do the Conrad 30 program. And you can go ahead and then apply for the H-1B. Just the key is planning and starting early. And then you'll be able to change to an H-1B. I think this administration is intentionally trying to scare people, make people feel nervous to apply, and the courts are pushing back. But right now, you still can apply for an H-1B. It's not going to, the $100,000 law only affects you if you leave the US. And if you end up marrying a US citizen, then you can also explore the option of applying for an exceptional hardship waiver. And sometimes physicians like that as well, because then you don't have to work in an underserved area for 3 years. You could work wherever you want.
I like that you mentioned the noise and the rhetoric because it's so easy to read the headlines and sink into them and not really do the homework. Hey, but what are my options here? Maybe I should consult with a legal specialist, an attorney, and get actual valid recommendations that would work for my unique scenario because my scenario may be different from the next person, depending on multiple factors, how they moved into the US, how long they've been here, if they have any prior violations. And it's really important that we stop and just think about the information that's been thrown at us and just like with medicine, have the proper history, have a proper history and physical exam where you actually really look back and say, hey, what's going on here? And what is my assessment based on the facts, not based on what I think or based on what I read as a headline. So I really appreciate you pointing that out because you would think, oh, I would think that everything has changed and nothing is happening as it should. But from what you're telling me, for those who are physically present in the US, continue business as usual. Eat with delays, with setbacks, continue what you're doing and start early is literally what you're saying.
Yeah, and it is true that things have gotten harder
Yes,
and they are scrutinizing applications more, but you can still apply. And I think the headlines are designed to hijack you and get you fearful. And so things are still possible despite the challenges that are there. But if you have the right advice, the right team, then things are still possible.
absolutely. And then for the second person who we were going to also speak to, who's the person who maybe is in that process of now converting over from an H-1B to a green card, would you give the same recommendation to them?
And so if we're talking about H-1B to a green card versus marriage, that landscape has changed with that May 21st memo. So that one is being more prepared and being more proactive in the application and showing the positive equities in your application, showing how you're contributing to the US, you're a physician, if you worked in an underserved area or continuing to work in an underserved area, how you've always maintained your lawful status, you never were out of status. So you're building a case for yourself, showing why what the administration says is that you deserve to stay in the US. So now it's still possible, but it's going to require much more effort and being much more thorough in the application. And that I would definitely consult with an attorney. That landscape is still changing. Lawsuits will be filed, but it's not going to be immediate because it has to go through an administrative process before the lawsuit can be filed.
Absolutely. And on that note, we'll round up for the day. But if we wanted to reach out to you, book a session with you, consult with you, where do we find you?
The best way is to call us at 916-613-3553, or you can email us at info@ranchodlaw. I also have a channel that we weekly post videos, and the handle for that is at the Green Card Lawyer, or you could do a search under our name, Ranchod Law Group, and subscribe to that to just keep updated on these latest issues.
Awesome. Thank you so much for your time and for sharing with us. I think these are all questions that I've gathered from my audience over the last few months of navigating these questions regarding J-1, H-1B, and green cards, and what's fact and what's fiction. So we really appreciate you taking a time out of your busy day to speak with us and give us some more insight. We'll have all Mr. Ranchod's information in the show notes. We'll make it easily clickable for you. If you're watching on YouTube, you'll be able to find this page and the hyperlink in the show notes. And if you receive this by email, same thing, you'll have all that information in there as well. So you can reach out and we'll have the number so you can quick dial, one stop dial from your phone. Thank you for joining us, Mr. Ranchod. We hope you have a great evening.
Thank you, Dr. Lemma. It was fantastic.